Hello everyone, I am Sergio Maldonado and this is Masters of Privacy, a set of interviews covering the intersection of marketing, data, privacy and technology with a clear goal in mind, which is redefining the relationship between people, brands and media around transparency and control. Which is to say, we're aiming for real customer centricity, or if you will, human centricity. We regularly talk to DPOs, CMOs, CDOs, and whoever else we find interesting and able to share valuable insights. So we hope you like it. Please do reach out if you have any ideas on future topics or speakers. So we have Matthias Eigenmann here today, and he's a Swiss lawyer with over 10 years of experience in technology and data protection law. He currently works as legal counsel and DPO at Decentriq, which is a data cleanroom. And he's also an advisor on data protection matters to a large hospital in Switzerland. Prior to this, he spent several years working in tech and data protection law at a law firm, as well as an in-house counsel for IT contracts and data protection at PwC Switzerland. With Matthias, we have had what I believe is our fifth interview covering data clean rooms. It's our third on this channel, so in English, having previously had InfoSum's DPO and Damien Defontaine from Tumult Labs on the show. If on the technical side we covered differential privacy with Damien, and on the legal side we covered joint controllership and legal basis with Nicola Nuet, we are today exploring two things. First, confidential computing or trusted execution environments in the context of privacy-enhancing technologies at a high level. So, of course, because he's a lawyer, primarily to understand its impact on our respect for the general principles of data protection. And second, we'll spend most of our time revisiting contractual relationships between parties in a data collaboration deal, legal basis involved in making such a deal work, and the manner in which different business cases result in different approaches to compliance. Let's go for it. Matthias, thanks for joining me.
Thanks for the opportunity.
It's really good to have you. And the first thing I need to understand is confidential computing. What does it do for us?
Confidential computing is one type of privacy enhancing technology, and it's actually defined by the Confidential Computing Consortium as the protection of data in use by performing computation on a hardware-based attested trusted execution environment. So a TEE. You will regularly hear this term, the trusted execution environment, or TEE, in the context of confidential computing. And that is actually something that is baked into the hardware, so baked into the chips. And a trusted execution environment has some key properties. I think the three key properties of a trusted execution environment are data confidentiality, data integrity, and also code integrity. So that means that the data in a trusted execution environment cannot be accessed from the outside. It is, as I said before, encrypted not only in transit and at rest, but also in use. It provides data integrity, so the data cannot be manipulated by anyone outside, and also the code that is executed. And I think this is going to be an important point for later in this podcast. The code that is executed in a trusted execution environment cannot be manipulated, and it can be attested from an independent third party that only that code has been executed. So these are the key properties of a trusted execution environment, and all of these have different aspects that are related also to data protection.
So attestation seems to be a key piece. Somebody has to tell us that these pieces of hardware, and I understand it can go very deep. It can happen at every level, like at CPU level or at a higher level in the hardware. So who does the attestation? Who do we trust to know that this is really confidential at hardware level?
This is an extremely technical question, and I think to to explain how the attestation mechanism really works, you rather have to talk to some of the technical people rather than to me as the lawyer.
Don't worry, for another day.
But in the end, it depends on the hardware manufacturer. So if you're saying confidential computing is always hardware based, to some extent, you have to trust the hardware manufacturer. For instance, you have confidential computing technology built into Intel chips. So the remote attestation will always in some way imply that you trust Intel. However, obviously, Intel as the hardware manufacturer is not directly involved in the processing operation, so it's further away. So basically, you trust someone who is not involved in the processing itself and therefore does not touch the data.
Good. So we trust like Azure or Google Cloud Platform or Amazon as the sort of platform as a service provider. Or the infrastructure provider?
Not necessarily. You do not need to trust necessarily the platform. You trust the hardware provider, the original hardware manufacturer.
Thank you. That's great. So then, how does this affect core principles? So in the GDPR, Article 5.1a, lawfulness, fairness, how does it affect them?
Yeah, I think the first one that comes to mind, obviously, when we're talking about strong encryption, is the integrity and confidentiality principle, and the obligation to implement appropriate technical and organizational measures to avoid data loss, etc. So this is probably the most obvious one, and of course, if you have strong encryption on all states of data at rest, in transit, and in use, you have stronger measures to avoid data loss, data leakage. In recent IT security research, it has been shown that attackers more and more move to attacking data while it's in use because encryption at rest and in transit is so widely used, and they have realized that data is in its weakest state while in use. So there are various new attack models that are trying to attack data while it is in use. So this is addressed with confidential computing. Now, while this might be the most obvious data protection principle that is, let's say, enhanced or improved by the use of confidential computing, this automatically also has an effect on other principles. For example, fairness, because fairness is about reducing the impact on the data subject's privacy rights, reducing interference with privacy. Well, the better you protect the data, the lower the interference is with the data subject's privacy rights. Another thing is that with confidential computing, two parties, and I think this is a key use case in this edtech industry, it allows two parties to work together on their combined data. And it does so without the need for those two parties to expose their respective data to each other. So both parties can use their own encryption, put their encrypted data into a so-called data clean room, combine the data in the data clean room, analyze the data in the data clean room, and all of that without necessarily exposing their data to the other party that they are collaborating with. And there again, this is a way to reduce interference with data subject privacy, since exposing data to another party is associated with higher interference, obviously. And if you can avoid that, that's obviously great. So you have a positive impact on the fairness principle as well. And then there is also the principle, for example, of accountability. we were talking about code integrity before, and I mentioned it before that this code integrity part is going to be an interesting point to discuss later on, is if you have code integrity and if you have attestation that only a certain code has been run and executed on the data, it puts you in a position to account for what happened for the data. And that is exactly what the GDPR requires controllers to do, that they are able to demonstrate that they complied with the law and what they used the data for. And with confidential computing and this remote attestation mechanism, you can really account for the very last detail of what you did to the data. I think I haven't seen anything comparable in terms of accountability. Usually you'd comply with accountability principles on a way lower level and you'd still comply. But here you can really demonstrate what you did, what has been done, who had access to the data at what point, what computations, what analysis has been executed, what was the output. All of that can be attested.
Very good. And since you know more and in greater detail, it also affects transparency, which is coupled with fairness throughout the law. So if anyone wanted to know, or you wanted to share more about how these things or how data is being, analyzed together, for example, then now you have a way to tell more if people get to understand it. That is.
Of course. I mean, it always requires then that the party providing the confidential computing system is transparent about the code. And I understand that this is not always the case. For now at Decentriq, we are giving the parties interested the possibility to audit the code, to audit what has been run in the trusted execution environment, and then thereby, of course, have full transparency. I mean, transparency mostly concerns the data subject.
Yeah.
I don't think that the data subjects would be required for them to go into that level of detail. But I would not exclude, for example, a supervisory authority at some point requiring things like that. And then it's less about the transparency, but more about accountability.
It's only us sort of super nerds that go into the retailer's website looking for data partners when we hear they have a data clean room and we want to know, but it's us. It's a professional curiosity. Exactly. Nobody else cares.
Exactly.
Good point. Okay, so being even more practical. So now you've got two parties and both have first party data and they want to collaborate and they know both can get, it's a win-win scenario because they're exposed to shared audiences, but in different environments. So there's always something to gain out of analyzing data or finding better increased addressability and so on. Before we get to that, there's going to be an impact on the contractual relationship, on who is the controller. Do we have joint controllership? Are you always a processor? How does it impact the relationships?
Let's start with the easy ones, right? I mean, of course, if you have a party, maybe a retail brand that is collecting data from its shoppers in its online shop, it is a controller for their shoppers' data, of course. And then what we see on the other side, we usually have some sort of a publisher, a company with an online platform, news media site or something like that. And they have consumers, they have readers, users on their platform. And of course, those publishers are controllers for the data that they are collecting from their users. Now these are typically the two parties that would like to collaborate in a data clean room and then find ways to optimize the advertising of the retail brand that I mentioned first on the platforms of the online publisher on the other end. And they do so by combining their data, and then that's where it gets interesting, right? That's where the true question arises, namely, the question if combining the two parties' data in a data clean room and analyzing the data in a data clean room makes these two parties joint controllers. This is a question that is currently heavily debated, and unfortunately there is very little clarity as to that question, and there are very different opinions that are strongly influenced by region within Europe. So you could see that in certain regions in Europe everything tends to be joint controllership, and other regions in Europe where joint controllership doesn't seem to exist. That makes it extremely difficult for companies maneuvering all over Europe and trying to find a unified approach. As to your question, how confidential computing impacts this, as long as you define a data clean room in a way that the output, so the data that after the computation is delivered back to one of those parties, is only aggregated insights, aggregated
Yes.
data, I would argue there is absolutely no case for joint controllership, because neither party gets any means of having access to the other party's data. That means that the other party's data, from the first party's perspective, is not personal data. And if the data is not personal data, it cannot possibly be a controller, meaning it can also not be a joint controller. Okay. Now, I think this case is pretty clear. If you do lookalike modeling and then there go an aggregated lookalike model, or not the model, but the computed output on the first party data of the data recipient goes out to that party, and the publisher learns nothing about any data subject in the advertiser's data and vice versa. There is just no case for joint controllership. Now, there's another thing, that there is the retargeting case, right? There is the case where you would have an advertiser and a publisher matching their data, and then the overlap of the data going typically to the publisher, because the advertiser says, well, I already know these people, these are my shoppers. Happens that they are also readers of yours, media consumers of yours. I want to target them with my advertising in your platforms again. And then obviously the publisher learns something about the people in the overlap. The publisher learns that these are customers of the advertiser. So there is a transfer of personal data from the advertiser to the publisher. Now, I think this can be debated whether this causes joint controllership or not. In my opinion, it should not. It should not, because of the intent that the European legislator had when it created this clause on joint controllership. The intent was to avoid that the data subjects would lose any of the protections granted by the data protection laws, because two parties work together and their roles and responsibilities might be unclear, or there might be gaps. And in this case, I believe it's no different from any other transfer of personal data from party A to party B. And not any transfer of personal data from party A to party B causes joint controllership. So in my opinion, there is no case for joint controllership. However, I acknowledge that there might be different views on this topic.
So let me try and simplify that. Two business cases for now. One, analytics, and the output is aggregate data. And the output could be, at the most innocent level, basic insights out of computing data together. At a more advanced level, perhaps we do lookalike modeling, and the lookalike modeling that we do between the publisher and the retailer in the end is going to spit out, for example, topics if I wanted to match it with, for instance, the topics API, if that was a possibility, then I would get topics, but I do not get individual people, whether as cookies, email addresses, some sort of identifier at individual level, because I do not enable retargeting or specific one-on-one addressability, but instead cohort level or topic level or interest level, addressability. Again, it's aggregate data. You make a very strong case. I agree that is not, that can easily get out of the GDPR. And if we look at some cases, even the SRB case, the CJEU, I think we could get away with that in many instances where we say, look, the output is just aggregate data. And there's always going to be a way to get back to the individual if we start correlating additional data sets, but you do not have them. So with the data that you're facilitating, that in itself is not going to let them deduplicate that audience and get back to the individual. Therefore, very good case. So you made it very clear. I take personal data, first-party data from retailer, first-party data from the publisher, combine them, and the output can escape the notion of personal data. Now, the more delicate scenario is where we do handle personal data as the output. Let's say the output is data that we can activate using the means in ad tech that rely on granular, individual people, which is what we have today. Sadly, there's nothing yet to address topics that is sort of widespread, right? So despite Google's best efforts and others. So because we can't, and if you want to, reach out to people in the market, today's tools are built, first were built around third-party cookies, now around IDs, they're built around people. So as you say, now we do deal with personal data. So the question is, do we have joint controllership? As you're saying, joint controllership, it is about jointly defining the means and the purposes. And certainly there is a case that could be made where this is just a chain of independent controllers. So you release your burden, and then there's another party that decides on the means and the purposes, and you've done your part, and now they need to do their part. At which point, my question to you, long preamble, is legal basis. Does this mean that we need to we're expecting to have consent at the very outset, even though maybe you didn't know who your data partners were going to be at the time that you collected consent?
I think it's a multifaceted question as well, because there are different steps of processing that are involved in this. And you again have the perspective of the retail brand, the advertiser, and you have a different perspective of a publisher, and different processing going on each side as well. Now, if you look at the advertiser side, if we take the case where the data that is going out at the end of the processing to the publisher is personal data about customers of the advertiser, then that is a transfer of personal data by the advertiser to a third party that might have been unknown at the point of data collection. Most likely, I wouldn't say it's a black and white case, but most likely such a transfer would only be permissible with the data subject's consent, meaning that upon data collection by the advertiser, by the retail brand, this brand will have to collect the data subject's consent for future transfers to third-party recipients that need to be not named individually, but at least described in categories.
Yes.
And most likely such a transfer would only be permissible with the data subject's consent. I think this is again like this is the point where it's there's a strong distinction between this lookalike and prospecting use cases where no transfer of personal data is happening. It's only, as you say, innocent analysis, and in the end, we use our learnings to do something that has nothing to do with the individual data subject. And in this case, where we do transfer personal data, there is, to use the same terminology as I used in the beginning of this podcast, there is a higher degree of interference with the privacy rights of the data subject. And to justify that higher degree of interference, a legitimate interest might no longer be enough. There might no longer be an overriding legitimate interest. It's still legitimate, I would say, but it might not be sufficient, and therefore there might be a need for consent. But then you have on the other side, you have the data recipient, you have the publisher, and what the publisher does with that data, right? I mean, the publisher cannot collect consent for receiving data. However, the publisher will use, be that in a world of third-party cookies or first-party cookies or whatnot, there will be technical means to tie a device that will receive advertising in a browser, in an app, whatever. There will be technical means to deliver the ads to those devices because they are owned by a certain individual. And as soon as we do that, we're no longer only in a GDPR situation, in a clear-cut data protection situation. We are also in the scope of an e-privacy directive / e-privacy regulation. We are, even if that's not third-party cookies, these are not strictly necessary cookies. And then there is a clear-cut legal requirement for consent, not for processing of personal data, but for the use of specific technical means. And for that, we will never get around this consent requirement. But it's not this standard generic data protection question. It's much more specific, and there is much more specific regulation around it. And so what I'm trying to say is the online publishers nowadays, they all have frameworks in place to collect these types of consents, to use these identifiers to deliver advertising. And they have consent mechanisms and so on and so forth. And nothing changes. Nothing changes. The true improvement is that if you put a data clean room in the middle, and even better if it is a data clean room that uses confidential computing technology, to get there from the initial data collection on both sides, to combining the data, to sending it to the party that will be able to deliver the advertising, you minimize the interference with the data subject's privacy rights, and you will only transfer the data about those data subjects that are actually in the overlap in such a retargeting case. So you will not send over a whole bunch of data about people, and then the other one figures out, here I have 10% people in the overlap, and then I learn about 90% of other people that they are also customers yes. of that given retail brand's online shop. So that's not necessary for the publisher to learn. And with the data clean room in the middle, you avoid that. And I think this is the big advantage. This is the step change for privacy with DCRs.
Totally. I can totally see that. Much more efficient. The waste that goes into so many parties trying to compute and trying to look up a particular audience to see if there's a match, when you can already use high quality data. You know this is the target audience. You know this is the publisher's environment. Is there a match? If there is a match, let's make the most of it on both ends. Let's avoid waste. There's even some would say an environmental waste going on with so many parties pinging here and there. So I can totally see that. To rephrase what you said and digest it properly, if we were to put aside e-privacy, because maybe we can expand the exceptions for the necessity of a service, for a publisher to make a living, for a publisher to serve, to deliver news and so on. But if we were to put that aside, and we know that we're not really interfering with people's rights in order for them to be addressable, I think there's a very strong case to be made for legitimate interest when there's no one-on-one addressability. So the scenario that you were referring to earlier, where I'm retrieving some topics or some interests at high level, and those are not even at analytics level, at addressability level, because I'm only using them as large cohorts, and in principle this is not even personal data per se as it stands without additional data sets, then first, yes, if it's not personal data, we don't need to talk about legitimate interest. Second, if there is, then maybe there's a very strong case that the risk is very low and that you could strike a balance and get away with it. If we do need consent, my worry is always the same, is that provided that we need to gather proper, free, informed consent, that the amount of people that do agree, unless they are subject to, again, to blackmail with consent or pay, right, then it's going to be very low. So you're going to have, if you are a very small publisher, or on the other end, a small advertiser or a small retailer, then the amount of people that will say yes will not be enough for this to make it worth. So that for these things to work, we need hopefully to find a way to avoid consent. And I believe data clean rooms have one of the, maybe the best chance out there from my point of view, to be able to leverage first-party data in a way that can hopefully go around consent, either because there's no personal data involved in the transfer, or because there is a legitimate interest. And hopefully we can avoid that consent requirement. Matthias, any final thoughts? Any last ideas?
Yes, I mean, what you're saying is absolutely true, right? And I think we're taking it quite far here, right? I mean, we're talking about cutting edge privacy enhancing technology being used in this area, and as Decentriq, as a company, we're in this area, and providing this technology for the ad tech industry. And besides, we're providing it to financial institutions, to national defense, to healthcare and life science sector. And I would argue that in all of these areas, the privacy concern in the ad tech sector is probably the lowest. Yet the debate seems to be the most heated sometimes. And yeah, I mean, people need to see that this is top-notch privacy technology that is basically a Ferrari in a Fiat race, right? To put it with Zlatan's words, right?
Yeah. Matthias, thanks again. Thank you.
Thank you.
Okay, that's all for today. Please follow the Masters of Privacy channel on LinkedIn if you want to find some interview transcripts, cheat sheets, and other useful resources and surprises every now and then. On top of that, episode notes and other feeds are available on mastersofprivacy.com. Thank you for listening.